Hello friends, one of the questions that I get asked all the time is how does a court determine child support? Well, it's a great question, and today we've got you covered. We're going to go over how Florida courts determine a party's child support obligation. Welcome back to Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so when a divorce case involves children, in addition to figuring out the parental responsibility and the time-sharing schedule, a court will be very interested in trying to figure out each party's responsibility as it relates to child support. And that's right, I did not misspeak. I said each party's responsibility towards child support. And what I mean by that is that the child support ensures that both parents are financially responsible for the cost related to the minor children involved in a case. In the state of Florida, because the money is technically owed to the children, a lot of people are surprised to learn that neither parent can waive receiving child support because the money is not owed to the parents, it's owed to the children. Now, while attempting to calculate and figure out child support may seem difficult and challenging at first, keep in mind that in the state of Florida, a child support calculation is actually a formulaic process. What I mean by that is that Florida statute 61.30 indicates a diagram or formula as to what the relevant child support payment should be depending upon a couple's net income. Also, as I just alluded to, in the state of Florida, the primary factor used in order to calculate child support is a determination of the party's net income. Now we're going to go into this a little bit later in the video. Just want to say that net income for child support purposes may not be the same for filing purposes of your taxes, but we're going to talk about the differences shortly. Other factors that a court may consider is how many children there are. If there's one child compared to four, obviously the child support number is going to be different. Is there daycare or healthcare expenses for the children? Finally, the number of overnights will have a direct impact on each party's child support obligations. So let's hop into this. Let's discuss some of the nuances of Florida Statute 61.30, starting with the fact that the child support guidelines amount as determined by a court under this particular section presumptively establishes the amount of child support that a court must, now I say must, it's not optional, order for a minor child in either an initial proceeding or a modification proceedings. Let's also keep in mind that a court can enter an order of child support that varies plus or minus 5% from the guidelines amount when considering some of the relevant factors like the needs of the child or children, their age, their station in life, as well as the financial status and ability of the parties. For those that have an existing child support obligation, it is also important to note that the child support guidelines themselves may form the basis of a substantial change in circumstances to modify a child support payment. What I mean by that is that the statute indicates that if the monthly child support obligation is different either by 15% or $50, whichever one of those amounts is greater, then the court can find that there is a substantial change in circumstances that would justify modification of the ongoing child support based upon the child support guidelines. So that's very interesting. Now that we have covered some of the introductory aspects of Florida Statute 61.30, let's try to figure out some of the things that a court will consider and analyze when establishing the child support guidelines worksheet in a particular case. And as I mentioned in the beginning of this video, and it shall be a recurring theme, the primary factor in determining a party's child support obligation is net income. So how do we find a party's net income? Well, the first clue may be a party's financial affidavit. That's right, when a party gets divorced in Florida, they are often required to file a financial affidavit. In that financial affidavit, there is a whole section that lists income as considered under Florida Statute 61.30. What's great about the financial affidavit is that it starts giving you a little bit of insight as to how a party makes release their money and what the amount of income that is on a monthly basis. What is a little bit unfortunate about financial affidavits is that they are notoriously either incomplete or unreliable. I know, believe it or not, people don't necessarily tell the truth all the time on their financial affidavits, where they have to swear or affirm how much income they make per month and give that information over to the spouse. I know you're all shocked that people wouldn't necessarily tell the truth on those documents, but it is a thing. Additionally, in order to get to a party's net income, we first have to figure out what is a party's gross income according to Florida Statute 61.30. What's great about the statute is that it lists everything that is considered income, and I'm going to go over each one. I'm just going to name them. I'm not going to necessarily go into too much detail, but I will explain when necessary. Obviously, salary and wages is considered income according to the statute. So are bonuses, commissions, allowances, overtime wages, tips, and similar payments. Business income, whether it be from self-employment or partnerships, close corporations, or independent contracts. What business income means under the statute is gross receipts minus ordinary and necessary expenses to run the business. Disability benefits also counts as income, as do all workers' compensation benefits. Reemployment assistance or unemployment compensation, all is considered income by 61.30. Additionally, pension, retirement, or annuity payments are considered income, as are Social Security payments. Spousal support or alimony, and what I mean by that is if there's a previous order of alimony from a previous marriage, or if the alimony is being received in the current marriage or the current situation. Interest and dividends are considered income, for example, from brokerage accounts. Rental income, which is the gross receipts of the rent minus any type of ordinary and necessary expenses required to obtain that income. Income from royalties, income from trust, income from estates, all of that count. Reimbursed or in-kind payments, to the extent that they reduce monthly living expenses, are considered income. Also, gains derived from the dealings of property, unless that gain is not reoccurring. And remember, there also is one of those caveats, which is that monthly income shall also be imputed to an unemployed or underemployed person if the unemployment or underemployment is deemed to be voluntary on that parent's part. We did a whole video on underemployment. The statute 61.30 covers that in detail. I'm not going to get into that now, but remember that if a person is purposefully underemployed or underemployed, they may impute higher income on that person. Now that we have figured out what all of the gross income is under Florida Statute 61.30, we have to find out what Florida courts consider to be net income. Remember, and I will repeat it again, the primary factor to calculate child support in the state of Florida is net income. So remember that net income under Florida Statute 61.30 is not the same as net income for federal income tax purposes. So all of my wonderful accountants out there that are watching the show, chill for a second. I'm not talking about federal taxes. I am simply talking about Florida child support under 61.30. Remember that net income is obtained by subtracting all of the allowable deductions as set forth in Florida Statute 61.30. What's great about the statute is that the net deductions are also listed there. Some of the net deductions for purposes of Florida Statute 61.30 are the following: federal, state, and local taxes adjusted for the filing status and the amount of dependents that are claimed. In addition to this, federal insurance contributions as well as self-employment taxes, mandatory union dues if anyone is a police officer or a firefighter and they have a union that they have to pay every month, that gets reduced from gross income, as does mandatory retirement payments for those teachers that are out there or anyone else that has to pay a monthly retirement, that gets reduced from gross income. So do whatever a person pays in health insurance payments, as does court-ordered child support from a different case or a different child. It's a little bit controversial because it has to be court-ordered child support and it actually has to be paid in order for a person's parent's gross income to be reduced by that ongoing payment amount for the child support of an other child. And finally, alimony or spousal support pursuant to a court order from a previous marriage or the current marriage. Remember that the net income from each parent shall be computed by subtracting the allowable deductions under Florida Statute 61.30 from the gross income pursuant to that same statute. So that's the math as to how net income is calculated under Florida law. After the court has analyzed each of the parties' gross income and allowable deductions pursuant to Florida Statute 61.30, the court will then determine what each of the parties' net incomes are. This is an important point because what happens is that the net incomes of each of the parties will be added together, and that will be the combined net income of both parties, at which point the court will consult the grid that appears on 61.30. And when I say a grid, there's actually a grid that appears on that particular statute to see what the minimal child support is for that amount of combined net income. So are we done there? No, we're not, because the final step is when the court assigns each party their percent of that child support number. And how the court goes about that is that it will take each party's respective net income and divide it by the combined income. So if they do that, and let's say in an example, the husband earns 60% of the net income and the wife earns 40% of the net income, then that child support number will be paid 60% by husband and 40% by wife. And usually whoever has a child the least amount of times will pay the other parent that amount. In an equal time sharing situation, it may be different. In the business, we call this a pro rata share. The 60-40 instead of a 50-50 or the 70-30, that's a pro rata share for purposes of professionals in the divorce industry. So, are we done yet? No, we're not done yet, because we have to talk about some additional costs, starting with childcare costs. That's right, the parents have to pay for childcare due to either employment, job searching, or educational pursuits. Then the childcare costs are added on top of the minimal child support amount. And the childcare costs are usually divided by the pro rata or percentage share. So in our example, there would be a minimal child support amount plus the child care amount, which the husband in our example would pay 60%, wife would pay 40%. So that's how child care works, and there's other expenses that we're going to talk about next. We next have to talk about health insurance costs. That's right, provided that it is both reasonable and accessible to either parent, as well as any non-covered medical, dental, or prescription medication also has to be included on top of the minimal support and the child care costs. And in addition to this, it is divided by the percentage or pro rata share that we have been talking about. In our example, 60% of the cost would be paid by the husband and 40% would be paid by wife. Now, before we wrap up, we have to mention that the more overnights that a parent spends with the children, the less child support that particular parent will have to pay. There are rumors that there may be a magic number where in Florida, if a parent hits that magic number, they will start getting a discount in child support. But before we get to that magic number, it kind of makes sense, because the more time that a parent spends with a child, obviously their expenses are going to go higher. But in terms of a magic number, the statute reads that at the point that a parent spends at least 20% of the time with a child or children. What I mean by 20% is 20% overnights of 365 days of a year, then the court shall adjust the child support a little bit lower. And what that number is, if you take 365 days of a year, you multiply by 20%, the magic number is 73. Now, having 73 days with your children, obviously you're going to get a discount in child support, but children cost a lot of money. So whatever that discount is, it's probably not going to be enough to provide everything that you need for the children. And you should never use the getting a discount as a reason to spend time with your kids. You should genuinely want to spend time with your kids. All right, so that was a lot of information that we covered. A lot of it was mathematical and involves some formulas. I don't know about any of you, but whenever people start talking math and formulas to me, sometimes my eyes glaze over and I start thinking about my next vacation. But But nevertheless, if it was confusing in any way, or if there's any commentary, especially the part with the magic number 73, we would love to hear some comments from all of you. In the meantime, though, if you know anyone that would find this information useful, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor and like this video, subscribe to the Divorce Broadcast, and we will see you all soon. Thank you.